Picture a widow walking into her local bank branch in Ohio. She has her husband's death certificate in one hand and the bill for his funeral in the other. She asks the teller to transfer funds from his checking account to cover the cost. Instead, the teller looks at the screen, types a few keys, and freezes the entire account. Panicking, the widow pulls out a thick legal document with a gold seal. She slides her husband's last will and testament across the counter. The teller pushes it right back. "I'm sorry, ma'am. This piece of paper means absolutely nothing until a probate judge says it does." If you are over 65 and you are relying on a last will and testament to protect your life savings, I need you to put down whatever you are doing and listen to me very carefully. You have been sold the single most dangerous, most expensive lie in American finance. For decades, seniors have paid lawyers good money to draft a will, believing it keeps their family out of the court system. But a will does the exact opposite. A last will is literally a one-way ticket to probate court. It is not an automatic transfer of your money. It is an instruction manual written specifically for a judge. And until that judge reads it, validates it, and issues a court order, your bank has the full legal right to lock your family out of every dollar you own. So, if your will doesn't actually protect your money, what really happens on the day you pass away? Let us talk about day one. The day your family actually needs your money the most. Here is what nobody tells you about the banking system. When the bank finds out you passed away, whether a family member calls them, or the Social Security Administration automatically flags your file, their first move is to protect themselves, not your family. The moment they confirm you are gone, the bank drops a hard freeze on your individual accounts. Why? Because banks are terrified of liability. Imagine they hand your $50,000 savings account to your daughter just because she walked in holding your last will. If 3 weeks later, your son walks into that same branch holding a newer will, the bank gets sued. So their policy is brutally simple. They lock the vault, they freeze the money, and they tell your grieving family to go hire an attorney, get in line at the county courthouse, and come back in 8 to 12 months when a judge finally signs an official court order. During those months, the property taxes are still due. The funeral home wants to be paid, but the cash is trapped behind a frozen bank screen. I know exactly what some of you are thinking right now. I am married, so my husband or wife will just take over. This doesn't apply to us. But that assumption is exactly how spouses are getting locked out of their own money every single day. Let me speak directly to the married couples watching this. The ones sitting at the kitchen table thinking they are completely safe because they have been married for 40 years. Here is where the trap snaps shut. Yes, if you have a joint checking account, the surviving spouse usually keeps access. But look closer at your financial life. What about that certificate of deposit that is only in your husband's name? What about the savings account you opened years ago just in your name? What about the deed to the house or the title to the car? If an asset is in one name only, your marriage certificate does not work like a magic key. The bank does not care how long you were married. They only care whose name is on the screen. If your husband passes away and that CD is in his name alone, the bank will freeze it. If you slide your last will across the desk, they will tell you the exact same thing they tell a stranger: go to probate court. Suddenly, a widow who thought everything was fine is sitting in a lawyer's office, paying thousands of dollars just to get legal permission to access her own husband's savings. This is happening every single day in county courts across America. It is a quiet, expensive nightmare. But starting very soon, this quiet problem is about to become a massive national crisis, and it all points to a deadline you cannot afford to ignore. Why is this quiet problem about to explode? Because there is a ticking clock on the American legal system right now, and the alarm goes off on January 1, 2027. Back in 2017, the federal government passed massive tax and estate laws, but those laws came with a hidden expiration date. At the very end of 2026, those protections legally vanish. When that happens, the tax and inheritance rules change overnight. And when the rules change, millions of Americans are going to panic. Lawyers are already warning that the end of 2026 will trigger the biggest flood of estate updates in modern history. But here is how that hurts you, the ordinary senior. That massive rush is going to completely choke the local probate courts. Right now, a probate judge might take 8 to 12 months to unfreeze your bank account. By January 2027, the court backlog is expected to be so severe that simple cases could be trapped in the system for 2 years or more. If all you leave behind is a last will, your family is going straight into that massive legal traffic jam. Your spouse or your adult children will be permanently locked out of your money, while a stack of files gathers dust on a judge's desk. Your money will just sit frozen. And when grieving families get stuck in a legal nightmare that lasts for years, you have to ask yourself, who actually ends up getting paid? Let me tell you exactly who wins when your family gets trapped in probate court for over a year. It is not your spouse. It is not your children. The people getting paid are the lawyers, the court clerks, and the system itself. Probate is not just painfully slow, it is incredibly expensive. In many states, the court system and the attorneys take a percentage of your total estate just to process the paperwork. On average, the probate process drains 3 to 8% of everything you own. Let me put real math on that, because percentages do not always sound scary until you see the dollar sign. Imagine you worked your entire life to pay off a $300,000 house, and you managed to save $100,000 in the bank. That is a $400,000 estate. If probate costs your family 5%, that is $20,000. That is $20,000 taken straight out of your children's inheritance or your widow's survival fund. And for what? For a lawyer to file paperwork? And for a judge to stamp a document telling the bank to do exactly what your last will already said to do? That is not a tax. That is a legal toll booth. It is your hard-earned money quietly being drained away just to prove you are dead. But here is the good news. The news that those lawyers do not want you to know. You do not have to play this game. You can legally opt out of this entire system. Let me show you exactly how to bypass the judge entirely. Here is the first and easiest move you can make to protect your cash. It costs absolutely nothing, and it completely overrides your last will. It is called a payable on death designation, or a POD. When you add a POD to your checking or savings account, you are giving the bank a direct, legal instruction on exactly who gets that money the moment you pass away. And here is the secret that makes this so powerful. A POD does not go through probate court. It completely bypasses the judge. It bypasses the lawyers. It bypasses the fees. If you have a last will that says your son gets your savings, the bank freezes the account and waits for the judge. But if you have a POD naming your son on that exact same account, the will does not even matter. The POD wins. Your son simply walks into the bank with your death certificate and his driver's license. The teller looks at the screen, sees the POD, and hands him the money right then and there. No freeze. No court order. No waiting in a legal backlog in 2027. You can add this to your checking accounts, your savings accounts, and your CDs. For brokerage accounts, it is called a transfer on death, or TOD, and it works exactly the same way. This one simple move secures your cash instantly. But we have a problem. A POD fixes your bank accounts, but what about your biggest asset? What about your house? This is the ultimate replacement for your last will. This is how the wealthy protect their families, but it is exactly what middle-class seniors need right now to avoid the court crisis. It is called a revocable living trust. Here is how it works in plain English. Right now, your house and your money are in your name. When you die, a judge has to figure out how to move them out of your name. That is probate. But when you create a living trust, you take your house and your big assets and you put them inside this legal box. You are still the boss. You are the trustee. You still control everything. You can sell the house, you can spend the money, and you can change the rules anytime you want. But here is the magic trick. When you pass away, the trust does not die with you. It keeps living. The backup person you named, your spouse or your adult child, simply steps into your shoes instantly. They open the box and hand out the assets exactly as you instructed. There is no probate court. There is no judge. There is no massive fee draining your estate. The transfer is private. It is immediate, and the bank cannot freeze it because a judge is not involved. A last will tells a judge what to do. A living trust cuts the judge out entirely. It legally removes your family from the 2027 court backlog before it even starts. You fund the trust with your house, and you protect your cash with PODs. Together, they create an iron wall around your money. But even with the best trust in the world, there is one massive gap that a will completely fails to cover. And it is the one thing that terrifies seniors more than anything else. Let us talk about the scariest trap of all. Your last will has a fatal flaw, and it is a flaw that destroys families long before anyone actually passes away. Here is the cold, hard truth. A will only works if you are dead. But what happens if you do not pass away, but you suffer a severe stroke? What if you develop early dementia and simply cannot manage your own finances anymore? You are still breathing, but you cannot sign a check or authorize a bank transfer. Most seniors assume their spouse or their adult children can just step in and handle things. They cannot. If an account is in your name, and the bank realizes you are legally incapacitated, They will lock that account down immediately to prevent fraud. And if your family tries to use your last will to get access, the bank manager will look right at them and say, "This person is still alive." This document is completely useless. So, what happens next? Your family is dragged into a completely different legal nightmare. Guardianship court. A judge, a total stranger, now has to hold a hearing to decide who gets to control your money. The judge might not even pick your spouse. They could appoint a state-run professional to pay your bills, and that stranger will charge an hourly rate directly out of your savings while you are sitting in a care facility. Your money is frozen, and you are still breathing. So, how do we close this dangerous gap? Here is exactly how you stop a judge from taking over your life while you are still living. You do it with one piece of paper, a durable financial power of attorney. The word durable is the absolute key here. A standard power of attorney becomes completely useless the second you lose your mental capacity. A durable one is specifically designed to survive and stay strong exactly when your memory fades or a medical emergency strikes. When you have this document properly signed, you are legally appointing the person you trust most, your spouse or your most responsible adult child, to step into your financial shoes immediately if you cannot. If you suffer a severe stroke on a Tuesday, your daughter can walk into the bank on Wednesday holding this document. The bank legally has to listen to her. She can pay your mortgage, manage your taxes, and access your cash to pay for your medical care. There is no guardianship hearing. There is no judge freezing your accounts. And there is no state-appointed stranger charging your estate an hourly rate to write your checks. This document keeps the control strictly inside your own family, right where it belongs. Now, if you follow this strategy, you have your PODs protecting your cash, a living trust protecting your house, and a durable power of attorney protecting you while you are alive. You have built a perfect financial fortress. But there is one massive detail left. What exactly are you supposed to do with that dangerous old last will that is still sitting in your safe deposit box? So you have the trust, the PODs, and the power of attorney ready. You might be tempted to go to your safe deposit box, pull out that old last will, and run it straight through a paper shredder. Do not do that. Throwing a will in the trash does not legally erase it. If a copy of that old will exists anywhere else, at your old lawyer's office, or in a dusty filing cabinet, a disgruntled relative can still find it. And if they bring that old copy to a probate judge, it triggers an expensive, drawn-out legal war between your new trust and your old will. To truly destroy a last will, you must legally revoke it in writing. When you set up your new living trust, you or your attorney must include a specific legal sentence that explicitly revokes all prior wills and codicils. That one single sentence legally kills the old document. It turns the old will into worthless paper. Once you sign that revocation, the old will cannot hurt you, and the judge is locked out forever. Let me show you exactly what this looks like in the real world when a family gets this right, side by side with a family that gets it wrong. Let me paint a picture of exactly how this plays out in real life. Picture two neighbors living on the exact same street in Texas. We will call them David and Thomas. Both men are 72 years old. Both own homes worth $300,000. Both have $50,000 in the bank. And they both pass away in the exact same month. David did what most seniors do. He paid a lawyer for a standard last will. The week after he passes, his grieving daughter walks into the bank holding that will. The teller instantly freezes the account. The daughter is forced to hire a probate attorney. Because of the massive court backlog, it takes 14 months to finally get a judge's signature. During that time, the house sits empty, the property taxes pile up, and the court drains $15,000 from her inheritance in legal fees. 14 months of pure stress. Now look at Thomas. Thomas set up a revocable living trust and put a POD on his bank account. The week after Thomas passes, his son walks into the exact same bank branch. He slides the death certificate across the counter. The teller sees the POD override, bypasses the freeze completely, and transfers the cash instantly. Because the house is in the trust, the son takes legal ownership immediately. No lawyer, no judge, no 14-month wait. The entire estate is settled on a Tuesday afternoon, and it didn't cost him a single dollar in court fees. The difference wasn't how much money they had. The difference was the paperwork. And the best part? You do not have to wait for an expensive lawyer to start fixing this today. You do not need a law degree to start protecting your family, and you do not have to wait until you hire a lawyer. You can secure your cash by tomorrow morning. Here is exactly what I want you to do. Call your local bank branch, or walk right up to the teller window, look them in the eye, and use this exact sentence. I want to add a payable on death beneficiary to all of my checking and savings accounts. That is it. They do this every single day. They will hand you a simple, one-page form. It is completely free, and you do not need an attorney to fill it out. All you need is the full name, address, and usually the date of birth or social security number of the person you want to receive your money. Fill it out, sign it, and hand it back. In less than 5 minutes, you have built an invisible legal wall around your cash. You have guaranteed that a probate judge can never freeze those specific accounts. But remember, a POD only protects your cash. Once your bank accounts are safe, you still have to protect your house and your bigger assets before that massive 2027 deadline arrives. We are staring down a hard deadline. January 2027 is coming fast, and the court backlog is going to trap thousands of families who relied on old advice. So let me give you the exact checklist you need to survive it. Do not skip a single one of these steps. First, lock down your cash. Go to your bank this week and put a payable on death designation on every single checking and savings account you own. Second, bypass the judge for your big assets. Set up a revocable living trust and officially transfer the deed to your house into that trust. This is what keeps your real estate completely out of probate court. Third, protect yourself while you are still breathing. Sign a durable financial power of attorney. Pick the person you trust most to step in if you ever have a medical emergency, so the state cannot take over your life. And finally, officially kill the old will. Make sure your new trust documents contain the specific legal sentence that officially revokes all prior wills. Do this, and you have built a perfect financial fortress around your family. When you pass away, the transition will be quiet, private, and instant. Your family gets your money, and the court system gets nothing. Before you sign any new documents, remember that this video is for general education, not personalized legal or financial advice. Every state has slightly different rules for trusts and estate planning, so please verify your specific situation with a qualified local professional to make sure your paperwork is perfect. But do not let that stop you from taking action today. The court system is perfectly designed to drain your money if you choose to do nothing. If this video opened your eyes, do me one crucial favor. Share it with just one person over 65 who still thinks their old last will is protecting them. They are walking straight into an expensive trap, and you might be the only person who can warn them before it is too late. Subscribe and turn on the bell so you never miss a warning, and I will see you in the next one.